Contract law. Contractual term or representation. Statements made during the course of negotiations could amount to a contractual term or a representation. It is important to know whether a particular statement is a contractual term or if it is a representation, as this will determine the appropriate cause of action and remedy available. If the statement amounts to a term of the contract which is not fulfilled, the representee may sue for breach of contract. If the statement is merely a representation which turns out to be untrue, the representee may bring an action for misrepresentation. In deciding whether a statement amounts to a term or representation, the courts look at 4 factors. 1. The parole evidence rule. 2. The relative expertise of the parties. 3. The importance of the statement and reliance. 4. Timing of representation. 1. The parole evidence rule. Where the contract has been put into writing, only the terms included in the written document are terms. Any verbal statements will be representations. 2. Relative expertise. If the representer has the greater knowledge, it is more likely to be a contractual term. Conversely, if the representee has the greater knowledge, it is more likely to be a representation. In Oscar Chess v. Williams, the defendant traded his car in to get a newer car from a car dealer. He had misstated the date of registration. The court held this was merely a representation, as the purchaser had greater knowledge on the year of car models. In Dick Bentley v. Harold Smith Motors, the claimant asked the defendant to find him a suitable car. The defendant was a car dealer specializing in the prestige market. The defendant recommended a Bentley and told him it had only done 20,000 miles since having a refit. In fact, it had done 100,000 miles. The statement was held to be a term as the defendant had specialist knowledge. 3. The importance of the statement and reliance. Where the representee indicates to the representer the importance of the statement, this is likely to be held to be a term. In Bannerman v. White, the claimant asked the defendant if the hops had been treated with sulfur. He explained that if they had, he wouldn't buy them as he wouldn't be able to use them to make beer. The defendant assured him they had not been treated, when in fact they had. This statement was a term as its importance had been communicated. In Eke v. Godfrey, the seller of the boat stated, as far as he was aware, the boat was sound and free from vice, but advised the claimant to have it surveyed. The boat turned out to be defective. The statement was held to be a representation. Conversely, in Shawell v. Reed, the seller of a horse stated the horse was sound and free from vice. He said there was no need to get a vet to check him out. If there was anything wrong with him, he would tell him. The buyer told him he wanted the horse for stud purposes. The horse had an hereditary eye disease. The statement was held to be a term. 4. Timing. The longer the time lapse between making the statement and entering the contract, the more likely it will be a representation. In Routledge v. Mackay, there was a 3-week time lapse between misstating the year of a motorcycle and entering the contract. This meant the statement was a representation. In summary, in deciding if a statement is a term or representation, the courts look at whether it was in writing, who has the greater expertise, whether the importance of the statement was communicated, and the time lapse between making the statement and entering the contract. This video is part of a series of videos on contract law from www.e-lawresources.co.uk. Please subscribe to our YouTube channel www.youtube.com/e-lawresources. It's free to do so and will help us to keep providing these videos. Check out our website, which provides lecture outlines and case summaries. See also www.e-lawrevision.org.uk for revision games and quizzes. Thanks for watching.